Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in beautiful Peckville, Pennsylvania, and I am here with you each and every week at this time on this station to bring you, the Pennsylvania landowner, the information you need regarding natural gas development. Of course, and as always, I, Doug Clark, have never, do not, and will never represent oil or gas companies. I never have, I never will, I never, ever will. I represent the Pennsylvania landowner, royalty owner, and all oil and gas related issues, including but not limited to gas lease negotiations, reviews, consultations, pipeline, waterline agreements, royalty deduction issues, excessive shut-in, breach of leases, breach of pipeline agreements, estate planning, surface use agreements, unitization issues, you name it. Related to oil and gas here in Pennsylvania, give us a call, 570-307-0702. See if we can help you, and make sure you are visiting the websites. I've been doing some modifications, updating, creating some new sections of the websites. Check them out. If you haven't been there or you haven't been there in a while, check out the websites. Great information there. Let me give you my phone number, website address. Getting excited. I'm excited about what I'm going to talk about today. I really am. So website address, pagasleaseattorney.com. That's pagasleaseattorney.com. And a second website that I have is pipelineattorney.com. I have negotiated, consulted, worked on pipeline agreements with over 70 different companies across Pennsylvania on behalf of landowners. So if you're not using pipelineattorney.com as a resource, you should be. So check it out. You know, the show is general information, the websites are general information, but there's good information that you can use to become more educated about this system, the process, and how to protect you today and your family into the future. So make sure you visit pagasleaseattorney.com, pipelineattorney.com, and for any and all representation, regardless of your location, clients all across the country, in other countries, as long as the property is in Pennsylvania. Do a lot of this by telephone. We can always do it by person, but really encourage you, give me a call, call the office, see if I can help you, hear about the reviews and consultations. Great way to start with any initial document or representation, 570-307-0702, and keep listening each and every week at this time on this station for All Things Marcellus, because we're in 9 years now. 9 years I've been doing the show, so pretty soon it'll be 10. So we're not stopping. So keep listening. And why aren't we stopping? Well, here we go. I said, guys, I'm excited about today's show. And I'm going to tell a story. I'm going to tell a story in today's show. And I'm going to tell you guys right now that this story is dedicated primarily to Tioga County. I talk about it all the time because it's the biggest travesty, in my opinion, that I see in existence in Pennsylvania in the oil and gas field. And when I say it's the biggest travesty, in my opinion, I'm going to tell you, I don't see anything else close. If this travesty, in my opinion, is a 10, the next level that I see is about a 2. This is the worst that I see, and it is enormous. So I'm going to tell you the story, and what I'm going to do is I'm going to go through a complaint that I filed with my co-counsel in Tioga County Court of Common Pleas. We filed it. This is a legal case I filed, and it's against East Resources, Inc. and Sweppy LP. Pending case that we filed, and it deals with, what else would we be dealing with? This shut-in situation. Now, as always, remember, the radio show is not to be taken as specific information. These are my opinions. This is my position. I stand by them all. I believe in them. But I just want to give that disclaimer. And then also, I am going to read from this complaint and tell the story of this case from our side. We believe every single thing in this thing, what I'm going to tell you, is true. I believe it all to be true. But this is our side, and the other side gets to set forth their position. But I'm going to tell you what we believe that we can prove and what we have asserted as we believe to be factual based upon direct knowledge or information and belief from the circumstances. And you'll see what I mean here as we go forward. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station. And I'm going to tell you this, even if you're not in Tioga County, stay with me on this, because you want to hear something, you're going to be head scratching and saying, wow. And if you're somewhere else, you may say, whoo, thank heavens I'm not dealing with what these poor people in Tioga County have to deal with, because this is garbage. Again, all my opinion. So here we go. Here's the story. Well, let me give you a little wee bit of background. I hope you know, my goal as a lawyer, the number one thing I want to accomplish in my career is to stop what the heck is going on in Tioga County right now. I mean it. That is my goal. So if you're unhappy and you're out there in Tioga County, and you're a landowner and you've been shut in for many years, I want to hear from you, because I want to stop that. I do. And we're going to, and I'm going to do every single thing I can to stop it. But I need to hear from people, and I've already heard from a bunch of people, and we're going to bring more actions. We're going to bring more actions, because this cannot stand. So let me tell you the story. I'm going to tell you the story of our case that we filed. I filed on, let me give you the exact date, September 18th, 2019. So here we go. Again, I'm going to tell the story. So in this particular case, I'm going to read from some of the complaint. This action, meaning this lawsuit, arises out of two separate oil and gas lease agreements between the plaintiff's predecessor in interest, meaning somebody who owned a property before the current owner, and the defendants under the lease. So we're suing, in this case, both East Resources and SWEPI LP. We say that the leases, there are two leases involved in this case for two different parcels. Usually there's only one lease, but hey, this case there's two. These leases were executed, meaning signed, in December 2005 and February 2006. And each one of these leases carried a 5-year primary term that would expire. The first lease would expire in December 2010, and the second lease, the 5-year term, would expire in February 2011. Unless the defendants, meaning the gas companies, began developing the land so that they could extract natural gas from the leased property or neighboring lands that are combined or pooled into a production unit. Once these neighboring lands are combined and pooled into a production unit, the gas companies would need to drill a well or wells on just one of the leased properties contained within that production unit in order to access the oil and gas that's beneath the unit, beneath the properties in the unit. The next allegation. In October 2010, East Resources Management, LLC, began drilling a well on property that was owned by, and these people are not our clients, they have the well site on their property, Roger and Charlotte Smith, the Smiths, which was completed in November 2010. So the well was drilled, started in October 2010, and was completed in November 2010. Then, on December 9, 2010, East Management, LLC, combined and pooled together the plaintiff's property with other leaseholds into the same production unit as the Smiths, where the well was located, And as of the date of filing the complaint, so on December 9, the property is unitized. December 9, 2010. In October 2010, 2 months earlier, the well was started. In November 2010, it was completed. Then December of 2010, the plaintiff's property, our clients, were placed into a pooled unit where this vertical well was located. So despite drilling the well in 2010, SWEPI did not produce gas from the well or develop the gas production unit, which is the Smith unit, where the well is located. They didn't do anything. Instead, SWEPI tenders annual $5 per acre shut-in payments to the plaintiffs in lieu of producing and marketing gas that would generate royalties for the plaintiffs. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. I'm going through a complaint that we have filed, that I filed in September against SWEPI and East Resources regarding the shut-in issue. So continuing on. So we now have, as of the date of filing the complaint, a well that, number one, has never been hydraulically fractured or stimulated. Number two, has never been connected to a pipeline. Number three, our position is not capable, the well is not capable of producing gas. Number four, the well has never produced gas. Number five, the well has only 10 feet of the well bore that's actually perforated in the Marcellus Shale Formation. We also have information, number six, that this well is scheduled to be plugged in the year 2022. Number seven, no other wells have been drilled to develop the plaintiff's leased property. And number eight, we state that there are no other contractual basis exists to maintain these leases. Thus, we say they have terminated and must be released. We go on. So here we go. Let me just kind of reset here. So this is the complaint for anyone just joining. This is the complaint that I filed against East Resources, Inc. and SWEPI LP on September 18, 2019. And summarizing these basic allegations and just real quick summary for those who just joining here, we have to summarize. Again, this is assertions in the complaint. There are two oil and gas leases. One was signed in December 2005, one in February 2006. They both had 5-year primary terms, meaning the first lease would expire in December 2010, 5 years from when it was signed. The second lease would expire in February 2011, unless something was done to maintain the lease. So what do we have? We have December 2010 as the date the first lease would expire. So what happens? In October 2010, East Resources Management LLC, one of the prior owners of the lease, they drilled a well. They started in October, they finished in November 2010, and then on December 9th, 2010, right before the first lease was about to expire, they recorded a declaration of pooling and unitization to say, we have held this property, the plaintiff's property, in this Smith unit, all right before that was about to expire. Now, here we go. So what do they do from there? So since that time, they have been paying the plaintiffs $5 per acre for these shut-in payments. As we sit here at the time of the filing of this complaint, we have the following facts that we assert on our side, which, guys, you probably, many of you in Tioga County have these facts. So hopefully this stuff is ringing bells to you and you're waiting for the next time for me to say my phone number so you'll call to see if we can fight for your case too, because this has to stop. So what has to stop? Here's what I say has to stop. We say as the date from 2010, November 2010, the well was completed. December 2010, a DPU was filed to form a unit. Here we are 9 years later, and plus 9 years. 9 years later, there's never been any production. Well, let me go back. 9 years later, here's our position. The well, number one, has never been hydraulically fractured or stimulated. They never fracked a well. Number two, this well has never been connected to a pipeline. Number three, this well in our position is not capable of producing gas. 4, this well has never produced gas. 5, there is only 10 feet of this wellbore that's perforated in the Marcellus Shale Formation. Only 10 feet. And remember, it's not hydraulically fractured. Oh, number 6, I have direct evidence that SWEPI intends to plug the well in 2022. The well that was drilled 1 month, 1.5, whatever time, we'll say 1 month before it was going to expire. Unitized days before it was going to expire, the lease. It is now scheduled to be plugged. And SWEPI says, this is how we're holding your lease. With the well, again, that we say, has never been hydraulically fractured, has never been connected to a pipeline, has never produced gas, cannot produce gas, has 10 feet of wellbore perforated, is scheduled to be plugged in 2022. No other wells have been drilled that impact these leases, and there's no other contractual basis to maintain these leases. That's our position. And we, again, stand by that position very aggressively. And for anyone out there in Tioga County, and I know there's so many of you guys, like, if this stuff sounds familiar, like, this is what we're talking about. This is what we need to stop. Think about this. Drilled October to November, lease expires in December of 2010. This is all 2010. Now the company tells DEP they're going to plug this well. But yet they used the well to hold this lease and all the other leases in the Smith unit. That's their position. And we can't let that stand. We can't. I'm going to continue through the complaint as we go forward. And this is what I say. People talk. You know, I did a show years ago about talkers and doers. And I'm going to tell you this. I'll say it. I'm a doer. I am a doer. I'm not going to sit around and talk, oh, this is bad. I'm going to do something about it. So call me and let's do something about it. Because this is garbage unless you like being ran over. And as a guy who grew up on Airport Road, Armstrong County, we didn't like getting ran over. So we need to stop this. Stop this. 570-307-0702. 570-307-0702. 570-307-0702. I promise you, if there's a way to stop this, I'm going to do everything I can to stop it. I'll be right back after this break. I'm sorry, but this is driving me crazy, and we got to stop it. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. All right, I tried to calm down some over the break. Funny thing, I realized I forgot to take my blood pressure pill this morning. I think I'll be okay, though. I think I'll be okay. I'll take some later. But seriously, what I'm doing is I'm talking about the complaint that I filed on September 18, 2019, in Tioga County Court of Common Pleas against East Resources, Inc. and SWEPI on the shut-in issue. And I went through the beginning and the last segment of the first part of the complaint, and there's plenty more to go through. Now, I want to say that if you miss any of today's show or you want to go back and listen to it, again, because it's a really good show, go check out pagasleaseattorney.com, pipelineattorney.com. We will have the radio show. This show will be up and available Monday morning, as are hours and hours and hours of radio shows. So go check it out and get good information. And if you need representation, put the pen down, pick up the phone. We have to stop signing these bad agreements and just signing documents we really don't know what they mean, giving up enormous leverage in many cases, and in many cases, hundreds of thousands of dollars, in some cases even into the millions, because we're not informed. So we have to stop that. I want to help. Call my office, do a review, consultation, any representation. Again, regardless of your location, I have widows who are 80 plus years old that I've represented in the far southwestern part of the state and other areas. So don't be afraid. I don't care of the size of the property. I don't care of the distance. And if I don't think I can effectively represent you, I promise you, it'll be stated as soon as I feel that that's the case. I promise you. That's the only way that you can represent people. And no matter what, keep listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, each and every week at this time on this station. So let's get back to the complaint, and I'll see if I can stay composed a bit. Okay, so what we're talking about here is a complaint again filed in the Tioga County court system against East Resources and SWEPI LP for two different leases. They're in the Smith unit. The one lease is dated December 17, 2005. The other is February 18, 2006. So same client, same owners, but just a couple leases, different properties. So again, since this first lease, I'm going to just focus on one lease to make this easier to follow. The first lease, lease one, had a primary term that began on December 7, 2005 and would have expired, December 17th, and would expire on December 16, 2010. So let me go through some complaint again. So we assert that, like other Pennsylvania oil and gas operators developing the Marcellus shale gas, SWEPI and its predecessors, meaning companies that owned the lease beforehand, pools and combines leased acreage from neighboring properties together and into what are called production units. The developer will then drill a horizontal well originating on the surface of the landowner's property that bores straight down thousands of feet and then turns horizontally into the shale formation and is drilled out horizontally for thousands of feet so that the developer can access the gas that is trapped beneath the surface of the neighboring properties that are pooled together into a single production unit. So we're saying that that's how companies develop Marcellus gas and shale gas. I don't think that's disputable. Then we state, the developer extracts gas from the production unit by horizontally drilling and hydraulically fracturing the shale. Upon information and belief, when a Marcellus shale vertical well, like the one in this case, is not hydraulically fractured, gas recovery is extremely limited, if not impossible. Only the gas immediately surrounding the wellbore is retrievable, if at all. This is because without the artificial channels that are created within the shale by the hydraulic fracturing, the trapped gas cannot flow freely into the wellbore. So that's the situation. Summary: companies don't develop hundreds and hundreds of acres with single vertical wells that aren't hydraulically fractured. Doesn't happen. Doesn't happen. But Tioga County, you know what's happening out there. Yeah, you're not getting developed by these vertical wells. You're just getting held. Not developed. You're just killing time. Okay, going on. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You're shut in. You think you may have a claim? Call 570-307-0702. Going on. So remember, next allegation, let me summarize. We have a lease that expires in December 16th, 2010. On December 9, 2010, 8 days prior to lease 1 termination date, East Management recorded a declaration of pooling and unitization. And they unitized acres from both of these leases into the Smith R number 589 unit. Now let me tell you, I question a lot whether any of these leases are held, but you have to look at all these leases individually. So next allegation. Based on information and belief, East Management wanted to drill before the 5-year primary term expired so these leases would not terminate. If the leases expired, why did they want to do it? Well, if the leases expired in order to develop the plaintiff's property, with this landowner's property, the defendants or gas companies would have been forced to secure new lease terms which were less favorable to the company. Specifically, under the terms of current or more modern leases, the defendants were only obligated under the old lease to pay a royalty rate of 12.5%, which is the lowest rate allowed by law in Pennsylvania. And under the old lease, the defendants were not required to pay any additional per acre bonus payments. For the current leases also allow for post-production cost deductions from the royalty. And by not allowing the landowner to negotiate a new lease, they are not able to negotiate additional addendum terms that would be more favorable to those landowners. That's why SWEPI and its predecessors want to maintain these old leases. They don't want to pay a new bonus. They don't want to increase royalty. They want to keep paying without no deductions, or without deduction, or allowed to take deductions, excuse me. And they don't want you to get any other favorable addendum terms that can have value to you for you in the future. So let me go back again in some more detail. So now we get a little more detailed. On October 13, 2010, East Management began drilling the Smith 589 1V, which is a vertical well. They drilled that well straight down to a depth of 5,811 feet, and it terminated within the Marcellus Shale Formation. Though the well was completed drilling in November of 2010, the well was never hydraulically fractured. No water or chemicals were used to stimulate the well, and this is according to SWEPI's own well completion report submitted to DEP. In fact, also, SWEPI's well completion report shows that SWEPI and or its predecessors never planned to produce gas from the well, as there is a handwritten comment that I found dated on a document dated November 28, 2011 that has handwriting, quote, plan to plug well, end quote. We believe that SWEPI made this submission or represented that they planned to plug the well, as this information literally appears as a handwritten comment. Again, there is a handwritten comment as dated November 28, 2011 on SWEPI's own well completion report that has, quote, a statement that says, quote, plan to plug well. That's, again, handwritten, dated November 28, 2011. Goes on. Not only did SWEPI and its predecessors plan to plug the well without it ever producing gas, but even if they did intend to produce gas from the well, any gas that was produced, if at all, could not have possibly come from the acreage encompassed by the plaintiff's, my client's, leases. So even if that well could produce gas, it couldn't come from my client's property. Okay, let's go on. This is because, according to SWEPI's well completion report, SWEPI only perforated 10 feet of the well. Since the well was only perforated 10 feet within the Marcellus shale and was never hydraulically fractured or stimulated, the only natural gas that could have been produced, if any, from the well is the gas that is in extremely close proximity to the well. But on information and belief and using mapping data, the well in this case is located approximately, get this guys, the vertical well is not hydraulically fractured, not connected to a pipeline, has never produced gas, and we assert is not capable of producing gas, is only perforated in 10 feet of the Marcellus Formation. That well, guys, that Smith well, it's located approximately 6,825 feet from the closest lease 1 parcel, meaning that the edge of my client's leased property contained within the unit, when we use the mapping information, gives us approximate distance from the location of where this vertical well is drilled, not connected to a pipeline, not fractured, 6,800 feet, 825 feet from the edge of my client's property. That's a lot more than a mile. Oh, and check this out. I will say this with lease 2. You say, well, maybe he's not talking about lease 2 because it's real close. No, I'm just trying to make this simple. But the edge of the lease number 2 parcel in distance to the Smith well, approximately 8,600 feet. So reset, this is me, not the complaint. So here we go. Vertical well, drilled right before the lease terminates. Declaration of unitization days before the lease terminates. Never connected to a pipeline, never hydraulically fractured. Comment in a note from 2011 with DEP documents saying that there's a plan to plug this well in 2011. And the well was located from the distance of my client's closest property on one of the leases, 6,825 feet approximately. On the second lease, 8,600 feet. But yet SWEPI says, no, we can tender these payments and pay you forever. That's the position. So going on now, back to the complaint. So we say, accordingly, because this vertical well has never produced gas, plaintiffs have not received any royalty payments for gas production from the Smith unit or otherwise under the leases. So look, the Smith well hasn't produced gas. It hasn't paid any royalties, nor has any well paid royalties to these plaintiffs, to these landowners. Should sound awfully familiar, guys. And that's why I want to hear from you. So we go on. We state that by failing to produce or market gas under the leases within a reasonable time period, that the defendants and their predecessors failed to comply with the leases and Pennsylvania law. Meaning, we say you can't just sit there and do this. Instead, what do? Instead, the defendants, SWEPI and East, seek to inappropriately toll the leases in perpetuity, meaning make them go forever, by paying annual $5 shut-in payments simply because a portion of the acreage under the lease is encompassed within the Smith unit where the well was located. Even though my client, we say, is approximately, their property is approximately the closest point, 6,825 feet from the Smith vertical well that has never been hydraulically fractured, never connected to a pipeline, and has never produced any gas or produced gas in paying quantities. That's it. That's the situation. But as often is the case, there is more, because as a general proposition, we assert that SWEPI fails to establish a pipeline and produce gas from the well, and they later apply for regulatory inactive status. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. I'm going to take a break here, and we're going to talk about regulatory inactive status in the next section. But let me first say this. If these things sound familiar, if you're shut in 8 years or more, or you have a well on your property and you're shut in and you're not getting any royalties and you're just getting annual shut-in payments, I offer a free lease review. If you have over 100 acres and you're shut in for 8 years or more and you're not getting royalties from any other property, I will do a free lease review, let you know if I think you have a claim, let you know what I feel of the strength of the claim, and then you can decide if you want to do anything about it or not. But we have to do something to stop this, so I'll do these lease reviews without obligation. In that scenario, over 100 acres, 8 years or more, you're shut in and not getting royalties anywhere else. Also, if you have a shut-in vertical well on your property and it's been there since 2011 or before, I don't care of your acreage. I'll do a free lease review for you as well to see if you have a claim. So again, I want to hear from you. Call us. There's no obligation. There's none whatsoever. 570-307-0702. I'm going to keep talking. I'm going to explain more. This is a pattern, and you're going to hear me talk about what we refer to as a scheme. I'll explain it when we get back. You're listening to All Things Marcellus with me, attorney Doug Clark. Join me each and every week at this time on this station. I'll be right back. Welcome back to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. Join me every week at this time on this station. Been doing the show for 9 years, not stopping. Also, call regarding any representation. I have not, and will not represent gas or pipeline companies. 570-307-0702. We're doing a unique show today where I'm outlining the complaint that was recently filed by my office against SWEPI, by me on September 18, 2019, against SWEPI and East Resources in Tioga County regarding the shut-in issue. So I want to hear from you guys. So if you miss any of today's show, go back, pagasleaseattorney.com, pipelineattorney.com. Go tomorrow, check it out. It'll be on the website, today's show. All right, I want to get back into it because I got a lot more I want to cover. So, all right. So let me continue on with the story that we're telling in our complaint. So, often oil and gas leases include a shut-in clause, and under these provisions, the gas company may make a payment to the landowner called a shut-in royalty to keep the gas lease alive without the actual production of gas. As noted in our complaint, SWEPI's well completion report indicates that as early as November of 2010, SWEPI or its predecessors never intended to produce gas from this Smith well. When they wrote on their report, quote, plan to plug the well. SWEPI's well completion report has a statement, handwritten notation from November 2011 stating plan to plug well. Plan to plug well. Goes on. Then, okay, let me back up. So again, the well's drilled November, less than a month before the lease, or around a month before the lease is expiring. Unitization documents filed within days of the lease expiring. Then in November 2011, there's a notation on the well completion report that indicates there is a plan to plug this well. Then, in September 26, 2012, so the following year, SWEPI applies for regulatory inactive status. And that's the status that's requested by the well operator for non-producing wells. And the status lasts for 5 years, but can be extended on application. Goes on. Under the future, so they applied for regulatory inactive status. Under the future use of the well, there's a section in the regulatory inactive status application that has a section called future use of the well. So with regard to the future use of the well in their regulatory inactive status application, SWEPI writes, quote, significant reserves remain in place, and I plan to return the well to production, end quote. This was in direct conflict with SWEPI's well completion report of November 28, 2011, just 11 months earlier, where it indicates, quote, plan to plug well. More importantly, this well has never produced gas such that it could be returned is what they said, to production. The inactive well application that SWEPI submitted also states that the well was, quote, waiting on pipeline. Date of installation to be determined, end quote. Side note, remember, they said 11 months earlier they planned to plug well. They've never connected to a pipeline. Okay. Giving the false impression that SWEPI was waiting on approval for a pipeline that would be necessary to carry the gas from the well to the market to some unknown third party. However, upon information and belief, SWEPI had the exclusive authority to install a pipeline to transport the gas from the well on the Smith's property. So any notion that it was waiting on a third-party approval to install a pipeline is misleading. To date, again, as of the date of filing the complaint, and it remains true today, to date, the well has never been connected to a pipeline to transfer gas to market, despite being drilled in October of 2010 into November of 2010. Even though SWEPI had the right to install a pipeline to transport gas from a well on the Smith's property without the need for a separate pipeline agreement, on September 19, 2011, the Smiths executed a pipeline agreement with SWEPI that's actually recorded in the Tioga County Courthouse. I'll just tell you, instrument number 201111331. Meaning that they had authority. Why is the pipeline not being installed? Probably because they're never going to install the pipeline and they're never going to produce gas. They're just trying to hold this lease, buy time to develop it another way, to never have to pay you a new lease bonus, to never have to pay you any more royalty, to never have to negotiate a new lease, and to the detriment of you, if you were eligible for a new lease, in many of these cases, hundreds and hundreds of thousands of dollars, and when you count royalties, literally into the millions of dollars. And that's why we need to take action. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station for All Things Marcellus. Okay, moving on, continuing with the complaint. Thus, at all times from the date of that well's completion, SWEPI had the absolute authority to install pipelines that transport any gas produced from this well off the Smith property, either pursuant to the Smith's original gas lease or the pipeline agreement they signed. But SWEPI purposefully and intentionally chose not to install the pipeline to the well, any pipeline to the well. Why? Because, in my opinion, strongly, they're never going to produce from this well. In my opinion, this is just to hold the lease so they don't have to pay you a new lease, and I don't think they can do it, and that's why we filed this complaint. Going on. This gets really interesting too, guys. Check this out. On May 1, 2017, DEP, Pennsylvania DEP and SWEPI entered into a consent order agreement, which required SWEPI to place 178 of its Pennsylvania gas wells either into production or to plug them and restore the well sites. 178! That, ladies and gentlemen, is beyond outrageous in my opinion. The May 1, 2017 consent order agreement included an Exhibit A that contained a list of all 178 wells that are subject to the plug or produce requirement of the consent order agreement between SWEPI and DEP. You may recall I read from that list one time. Upon information and belief, that exhibit with all the listed wells on the May 1st consent order agreement of 2017 included approximately 122 vertical wells, 56 horizontal wells that SWEPI, by DEP order that they agreed to, is required to produce or plug. Then, check this out in this case, and these are the things, guys, we got to dig. We got to dig. Then on June 6, 2019, SWEPI entered into a modified consent order with the DEP. And you know what they did? They added 3 wells to the list that you had to plug or produce from, and lo and behold, the Smith well was on it. The Smith well was on it. And then I have an email. I have an email from SWEPI, from a person at SWEPI, to PADEP requesting to withdraw the inactive status application for this Smith well because the well is on SWEPI's 2022 well plugging schedule. Yeah, SWEPI now represents in writing to DEP that they're going to plug this well, that they want to have it withdrawn from the inactive status and being added as one of the wells that they have to plug or produce from. They want to produce or plug it in 2022. So they're never going to produce. They're never going to connect it to a pipeline. They're never going to do anything if what they say is true, except hold a lease from 2005 to 2006 for 10 years potentially or more past the primary term. That's their intention. And others, they're doing this for even longer. Never intend. And this has to stop. I got to go. I got one more segment. I want to finish this. Keep listening each and every week and today to All Things Marcellus. I'll be back right after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I have a short segment, a lot to get to, so I want to jump into it. So there's a scheme, in my opinion. Let's get to it. So SWEPI action, we say that SWEPI and East action are part of a larger pattern of bad faith and unfair and deceptive conduct. The assertions in the complaint, SWEPI and their predecessors, they sign these leases and they have a pattern of not developing them during the primary terms. Then they drill a vertical well, or right near the end of the primary terms of the lease, they drill a vertical well into the Marcellus formation. Then, upon information and belief, these wells, many of them are not hydraulically fractured, and many are not connected to pipelines and do not produce gas. Instead, defendants of SWEPI immediately cap and the drilled vertical well and subsequently apply for regulatory inactive status with DEP. Then, on information and belief, like the present case, SWEPI submits well inactive status requests seeking inactive status from DEP because the well is, quote, waiting for a pipeline with the date of installation to be determined or some other representation calculated to receive regulatory inactive status approval from DEP. Then we state that they then pay, SWEPI pays the shut-in payments and seeks to hold the leases based on these vertical wells. Then, based on information and belief, we assert that SWEPI typically unitizes 600 acres or more, or 600 acres, we'll say, in a production unit based on a vertical well, despite the fact that many of the vertical wells have not been hydraulically fractured, are incapable of producing gas, or incapable from a significant area of producing gas, significant area around the wellbore. Goes on. Our complaint goes on that SWEPI's unitization of hundreds of leased acres in production units based solely on a single vertical well drilled into the Marcellus formation and purporting to hold hundreds of acres under lease is done in bad faith, and that on information and belief that the PADEP office reports show that SWEPI currently has 101 vertical wells and 29 horizontal wells in regulatory inactive status in Tioga that have never produced gas. On information and belief, we assert that these wells have been drilled at strategic locations throughout the county, purposely calculated and positioned to attempt to hold as much acreage as possible by creating large production units that often adjoin or contiguous with other designed production units. We go on that SWEPI has sold or assigned or transferred approximately 34 inactive wells to Rockdale Marcellus in 2017. Rockdale now has 21 inactive status wells, and of these 21, all of them were acquired from SWEPI. And of the 34 regulatory inactive wells that Rockdale acquired from SWEPI, we assert that they're all part of the bad faith scheme and plan to lease oil and gas rights, to drill vertical wells in the non-producing Marcellus shale wells in strategic locations that are calculated to hold as much lease acreage as possible. We look at on information and belief that SWEPI currently has, as of the time of September 2019, 130 wells. 130 wells in regulatory inactive status. And prior to their assignment to Rockdale in 2017, SWEPI had 158 wells. And we have maps, and we include them in the complaint. And a review of these maps show the location where these wells have been drilled. And we assert that this illustrates how the defendants, including SWEPI, engaged in a calculated scheme to acquire leases from landowners and drill over 100 non-producing vertical wells throughout Tioga County in an effort to extend leases without ever producing in gas, instead paying those shut-in payments. Moreover, these non-producing wells were strategically located so that the defendants could unitize tens of thousands of acres to thereby maintain or maximize their lease retention. Despite several major other gas companies operating in Tioga, the only other company with any regulatory inactive status wells in Tioga County is Repsol, and they had 4. So, we allege that SWEPI and East have engaged in a pattern and scheme to acquire leases, drill vertical wells shortly before the termination of the primary terms, then pool combined substantial lease acreage to create huge units and hold all of this acres. Sound familiar, guys? 570-307-0702. Upon information and belief, SWEPI is currently attempting to maintain leases in the present case, as well as hundreds of other Tioga County leases with combined leasehold acreage totaling in excess of 20,000 acres by implementing a common scheme and plan to acquire leases, drill vertical non-producing wells into large production units, typically 600 acres or larger, not connect the wells to a pipeline, not produce gas from these wells, but instead pay nominal shut-in payments, typically ranging from $1 to $5 per year. We go on to assert that the defendants are acting in bad faith because it is impossible for this Smith well to produce gas under the terms of my client's leases in this case. Despite this, SWEPI maintains that the leases remain valid because they say it can extend the leases for decades or centuries, essentially in perpetuity, by fraudulently paying annual $5 shut-in payments simply because SWEPI has included a portion of the leaseholds into the Smith unit, which contains only a single non-producing well. A review of the regulatory inactive status wells in Pennsylvania demonstrates that SWEPI has and continues to engage in a county-wide bad faith and unfair trade practice and scheme to hold leases, as well as hundreds of other leases and tens of thousands of acres under lease by asserting that a non-producing vertical well justifies the creation of a 600-plus acre unit and can extend the leases forever by annual shut-in payments. No, we say you can't. I'm running against my time here. Again, I have to say, listen, go back, listen to today's show, pagasleaseattorney.com. You're in this situation. I want to hear from you. 570-307-0702. This has to stop. Keep listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Stop signing bad agreements. The landman works for the company, not you, the landowner. I will see you next week. Have a great, great week, everyone. 570-307-0702.